Welcome. I'm Barbara Marcum, and this is Friendship Focus. With me today is Jean Richards, who is an attorney, a local attorney, who I've had to the center several times. Welcome, Jean. One of the reasons I decided to do this show is because when COVID hit, if people didn't have things in order, it was almost impossible to get an appointment or see anybody. And with the large numbers, especially of elderly people who are passing away, once they didn't have that or take that opportunity, then it was too late when COVID came, and we lost hundreds of thousands of seniors and others across the country. So for me, this is really important because we've never faced this before as a nation, and now here we are, and who knows what the future will bring. So I wanted you to come on the show today and talk about your background and then talk a little bit about how important it is to get things in order.
Well, Barb, I always enjoy spending time with you, being at the center, and this is a treat for me to be here today.
Well, thank you for coming.
Sure, happy to be here.
Okay, so let's talk about estate planning and what documents are really important that people actually have. So having no documents versus having the documents, what happens to a family when there are no documents?
So there is an entire set of rules out there, call them laws, that tell us what happens when someone is ill, passes away, or needs somebody to make decisions for them. And I'd like to start first by saying the documents that we're going to talk about are tools. These are just tools, and you get to pick the tools that are right for you and how you want them designed and customized. If you do not have those tools, I think of it like a Wild West. We all have to go back to the law, the books, and say, well, now what do we do? They didn't tell us what to do. So there's a default set of rules that kicks in. And oftentimes that is not how people want things to go. So the rules are there, we can use them, but oftentimes they don't reflect a person's wishes.
Well, I think one of the biggest mistakes and I've heard several people say this at the center, well, I don't have anything, I'm just going to let my family fight over it. What kind of a big mistake is that? I mean,
right.
If you care about your family and their relationships with each other, because not having any documents is a plan for disaster.
Yeah, it not only creates tension in the family because it immediately raises the question, who's in charge? Who should be handling this? Well, what did mom or dad really want to have happen? It also tends to ignite family feuds. I think of it as you're just lighting a match and saying, here, go at it. You know, it's a tense situation, so families' emotions are running hot anyway, and so without some framework to work from, a set of rules that a person puts together, it can be difficult. The other thing that happens, back to your question, if you do not have legal documents, that can require getting the assistance of the court. We call it the probate court. Steps in.
Is that how you phrase it, the assistance of the court?
Yes, well, you know, a lot of people are afraid of the word probate, and I don't know if attorneys have been guilty of, you know, stoking that fear. Frankly, the probate process is there to work things out, sometimes to solve disputes, and that's the ones you always hear about, you know, the family fight in court. Well, it wasn't the probate court's fault. The family was fighting before they ever got in there.
Right.
The judge is there to resolve it and referee. So that's one side of the court. But the other side that we use regularly is simply the steps to go through to move something where it's supposed to go, like the house. How do we get the house from grandma, you know, to where it's supposed to be? Because they forgot, you know, mom lived in it, it never got redeeded, and now mom's passed, like, uh-oh, it's still in grandma's name, what do we do? So we're going to go through the probate process. That's the only legal way to move it to the heirs or whoever's supposed to receive it. So probate can be a good process. It's just unnecessary if you do your planning appropriately.
Well, you and I talked about this, and there's a list that we have from your office, which I think is really great, and it's a practical checklist, and it has where you can check off what you have, what you don't have, and make this a little bit simpler, because I will say it's intimidating. Like, people will say, what's the difference between a will and a living will?
Oh, good question. Yeah, and right, because they have the same words.
Right.
They both say will. Why do they have? You know, how
What's
are
the
they?
difference?
How are they different?
Yes.
You know, speaking of keeping it simple, so the checklist I gave you is really just a true false. You go through, you answer a few questions, you answer true or false. The idea behind it is if you mark something false, that's something to think about. You need to talk to an attorney or a professional about. So you're welcome to pass that out if you want to.
I will, and some of the things on here, like I do not have children under the age of 18. That makes a big difference if it's a minor. And these days, there are a lot of blended families. Do I have a blended family? Is this a second marriage? How are we going to work that out between all of the children? I don't care if my estate goes through probate. I have a durable power of attorney. So all of these things are nice because you can sit down and it's simple enough to fill it out. And thank you for offering to have this at the center so people can pick it up. And this is really a good first step before you do anything if you have done nothing so far.
If I could make a couple of points on that.
Sure.
This should not be a stressful process. I'm always glad, sometimes people show up to my office and they're literally trembling. And I know when I walk in, they don't know what's going to happen. They're at my mercy, you know, they're meeting with a lawyer. This has got to be a bad thing, and it should not be. I say there's two kinds of lawyers. There's the hand slappers and there's the hand holders. So I'm a planner. I work with families to get their affairs in order. So I'm a hand holder. This should not be a stressful situation, number one. Number two, it should be relatively simple and straightforward. We ask questions, we find out what's important to you and what's unique about your family, and then we give you the tools, that is the estate planning attorney gives the tools to make that happen. And I'd also like to say, if you keep these couple of concepts in mind, at least if your viewers will keep this in mind, it may help. What is estate planning? Even those words confuse people. It's simply having things arranged so it's for 2 points in life. Something happens, you're still alive, but you need someone to step in and assist you, either with legal decisions or with medical and care decisions. So you're still living, but you need some help. One set of tools allows that to happen. The other event is the one everybody always goes to first, which is, what are you going to do with my stuff when I'm gone? You know, I need a will. Well, that tells me they're thinking about when I die, and they hope that doesn't happen anytime soon, right?
That's probably why a lot of them haven't done it.
So that's part two.
Yeah.
All estate planning is dealing with those two events in life. Hopefully you get the documents, you tuck them away, and you don't have to use them for a very long time. But they're there if you need them. As we know, through COVID, life changes quickly.
On a dime.
On a dime. The other concept for people to keep in mind is I summarize estate planning as having the right person with the right power at the right time. So you need the right person having the power to do things, and they have it when they need it. If you've got,
as 1, 2, 3.
That's pretty much it. And everything else is making that happen. You know, working with what people own, you know, do they have real estate, do they have business, do they have bank accounts, do they have CDs, do they have annuities, do they have life insurance, do they have retirement accounts? Each one of those weaves into, or we weave all that together. Yeah. So it's really a lot of fun. You know, I've been doing this 25 years, and I just enjoy working with families. And you know, your audience needs to know this should not be stressful, and it shouldn't break the bank.
Well, you know, like when people say, okay, so a living will, or what happens to me, and a lot of that, and this is true even for myself. I sat down, it's like, do you want to be on a respirator? And it's like, well, so many things, and doctors never are good with a diagnosis is fine, but the prognosis is where, well, we just don't know. So do you want to be on a respirator for a couple of days if it's going to pull me through this particular thing, but do I want to be on it forever? No. So they sit there and they think about it and they go, well, I just don't know. Then it becomes so overwhelming, they just throw up their hands and say, forget it, I just don't even want to deal with this right now.
And that's probably because they're trying to make an important decision, and there's so many variables they don't know what to focus on.
Right.
Okay, there's a lot of noise in that conversation. That's one reason to sit down with an attorney, is because we see through all that and we can help guide people to the right decision. But you've asked a couple of times now, what is the difference between a living will and a will? So let's just answer that question.
Perfect.
So a living will, pardon me, beg your pardon? A living will, think of it as an advance directive for health care decisions or end-of-life decisions.
And that's what they actually call them, advance directives.
Right,
yes.
in Michigan specifically. So
Yes.
Michigan actually does not recognize, I gotta be careful with that word, our laws do not use the word living will.
Right.
We are an advance directive state. And if you think about it this way, when you have to check a box to say I do or do not want, resuscitation or, whatever, you're making a declaration like that, it's all or nothing.
Right.
Michigan uses the approach of having someone speak for you, having an advocate.
Right.
If you tell me what your preferences are and then something happens to you, you're in a situation where I need to make a decision for you, I'm your voice. I get to consider all the variables and say, well, I know this about Barb, this is the decision she would want me to make. Here's the tool, the legal document that gives me the authority to make this decision, all right? So that allows the
right
voice,
person.
it allows flexibility. I think of it as you're just drawing the box. Say, if I'm in this situation, here's how I would like decisions to be made. You're not saying it's all or nothing. A lady sat in my office one day and says, I want to do not resuscitate. Well, she was perfectly healthy, it seemed to me. And I was like, really? She goes, yeah. I said, I don't want to be resuscitated. I said, well, so if you fall out of your chair in the next 10 minutes, I'm not supposed to do anything. She goes, oh, no, I would want, because I'm fine today. I was like, well, then maybe we do not want to sign the do not resuscitate
Hands off under all circumstances.
order. Right. So you got to be careful with some of those documents. Do not resuscitate orders are a good tool to have when someone's really thought through that I'm at the end of my life or there's some condition I have and I just don't want to go through
I'm
this
98,
anymore.
please don't break all my ribs.
But I really like the Michigan approach of the patient advocate that speaks for
So do
you.
I.
And also, remember, the right person. There's nothing worse than a family at odds. You got one standout kid that says, no, keep them plugged in.
Yes.
And everybody else is like, doesn't make any sense.
No, and that's why the right person is so important, and that conversation with the right person is equally important.
Correct.
Because it's a lot of responsibility for somebody to pull the plug on mom.
Yes.
So when mom, knowing that this is what they would have wanted gives you a lot of ease making that decision rather than it being on you, that you're ending someone's life and you really don't know what they wanted. Right. Let's talk about the document. So when you have a document that gives somebody the legal power to make those decisions, where should this document be stored? Who should have a copy of this document? Dad and mom live in Florida 6 months out of the year.
Yes.
So how do people make sure that when you're looking at a medical staff and you say, well, I'm the one, and they go, show us.
So, right. A couple of practical ideas. One, first of all, have the document. Just what you say out loud, verbal, is really not helpful.
It's not.
So some people are, my kids know what I want. Well, okay, they might, but they may not be able to have the authority, right? They got to have the power. It's one of our 3 points.
Right.
But where do you keep this document? First of all, it should be on file with your physician. So if you have anytime you go to the doctor and you have a patient advocate designation, put that in the medical record. That helps. Number two, your person you've named to speak for you, your patient advocate, make sure they know that you have it, that they're named, and where it is. Maybe it's in the drawer.
Should they have a copy of that?
It doesn't hurt. Just remember that if you ever change your mind, you need to let them know, you're no longer my patient advocate.
You don't want two people showing up with,
Right.
yes, I'm the patient advocate.
One thing I tell, and this happened recently, maybe
I
as a
love
quick
stories.
example.
Yeah.
I had a client of mine I'd met with not too long ago and was in fine health, suddenly had a stroke. And I get a call from his child. His children lived way out of state on the coasts. And they said, hey, Dad's had a stroke. He's in the local hospital here in Michigan, near us. And we're not able to get any information because his 80-ish-year-old sister came to the hospital with him, and she's his emergency contact in his phone. So the hospital is considering her his patient advocate and his decision maker. And she's not talking to us. It wasn't that she was being mean, she was overwhelmed.
Sure.
She wasn't providing helpful information. She's like, I thought I was. And I was like, and I'm like, I know you are. I did the documents, okay? So she knew to contact me. Her dad had told her I worked with this attorney. So within probably 15 minutes, I immediately called the hospital, talked to the charge nurse. I said, I'm attorney for so-and-so. I understand he's there. I need to get a patient advocate designation. Well, that's his sister. I said, no, it's not. It's his daughter. And she's like, oh, I don't have anything. And I was like, what's your email? And so we may have faxed it, I don't know, but typically email or fax. So within 15 minutes, the entire
Situation turned
decision
around.
process had changed, and the right person was speaking for her dad.
Now, attorneys keep copies of the documents that they do? Or did you just happen to have that there? You do? Okay.
You know, different attorneys have different practices. They should at least have a copy.
I agree.
So in my practice, and this is unique to me, not unique to me, I know some others do it as well, I actually keep an extra set of originals. And I do that because over the years I've had a few instances like this one where dad is suddenly in the hospital. If you're in COVID, nobody knows where his book is.
Yeah.
Right? Where's that book? We know it's somewhere. I've got an extra set. So as soon as it's proven to me sufficiently that he's in this situation, then I can release it. You know, I don't just willy-nilly hand it out because somebody asked for it. But if in an emergency, it is available.
No,
so it's a
I
good
think
idea for the attorney to keep
really important.
a copy, and they should keep an original, in my opinion.
Yeah, what if somebody's house burns down and with them the documents as well?
Yeah.
So I think that's really smart.
Yeah, one of my favorites was a guy that his mom died, and she had disinherited, well, not disinherited him, she put someone else in charge of him because he had some, you know,
Problems.
Issues. and he called me and said, oh, hey, mom died, and I'm just going to take care of everything. And I said, well, no, you're not. Oh, yeah, I got her estate plan. I'm like, well, you got the old one. There's a new one. No, there's not. Yes, there is. So I called the person who was supposed to be in charge, and she's like, oh, yeah, I know. And so sometimes the most current documents disappear, you know, and we need to make sure they're available.
Absolutely. So if there are several documents I know that are involved in estate planning, what would you say would be the most important document to have? If you start with one document or two documents, what should they be?
I believe your most important document is your durable power of attorney. They're all important in different ways. If you remember a minute ago, I said if someone, we're planning for two events in life. If someone passes away, even if they haven't done a will or a trust or anything else, there's a set of rules that we know how things are going to work out. All right, may not have been their choice, but we have a set of rules. If a person's incapacitated, like this gentleman that had a stroke, if he had no power of attorney, we're not talking about giving away his, you know, inheritance to his children. We're talking about how do we make decisions with what he's got right now. Without that durable power of attorney, we're forced to go to probate court and prove that he's incapacitated, get someone in charge, and that is a process, and it can take a month to 2 months. And then if there's a disagreement among, you know, the kids or whoever thinks they should be in charge, it stretches out even longer potentially. So I think incapacity is the most stressful for families when they've suddenly got to step in, make decisions, pay bills, talk to the doctors, you know, deal with the credit cards or file the tax.
It was very stressful in my family, yes.
So that, in my opinion, the starting document, if you're not going to do anything else, at least have powers of attorney. If you pass away, we'll figure out what to do. There's a set of rules. If you're incapacitated, there's really not a set of rules. It's just,
are there different powers of attorney?
There are. So you have decisions about business, or let's say legal, financial matters. We call that a financial power of attorney. Then there's the decisions about health care, or your care, you know, where you're going to be, making decisions with the doctors, end of life decisions. So I think of those as the medical powers of attorney. So there typically are two: financial power of attorney and medical power of attorney. In the old days, attorneys used to blend those into one document, recommend that they be separated. There are two different types of decisions involved.
You might want two different people to do it, right?
Sometimes.
Okay.
You know, sometimes it's the same person wearing all the hats.
Okay.
But in some families, you know, Johnny's really good with money, and Sally's really good. You know, she's the nurse and the doctor, and she can make all the medical decisions. So they want to split that.
No, or this person is great and understands exactly what you want, but they have issues, so you don't really want to put them
Yeah.
in charge of your financial affairs.
Right. Correct. Yeah. And by the way, they're easy to talk about. We keep it simple. You know, you need a financial power of attorney. But when you actually focus in on that document, it's got a lot of many elements to it to talk about. Again, who should be in charge? Do we need more than one person at a time? Do we need, how much power should they have? You can give a person too much power.
Yes.
So sometimes we need to hem it in, restrict it. Sometimes I like accountability. So there's all
Absolutely
kinds of
right.
provisions. Just because you have a document that it has at the head of it, general durable power of attorney for finances, it doesn't mean it's going to work. It's like a toolbox. So my parents were missionaries in Africa, if I can venture off for a second.
Yes.
So my parents were missionaries in Africa. That's where I grew up as a boy. And we lived in the bush. And Dad was the old-fashioned missionary. He'd go out and, he had his circuit of villages and churches he'd go to. When he'd go out for his trips, he would load up the car with two of everything: gas cans, chainsaws, parts, tires, inner tubes, whatever. Why was he doing that? Because if you got out into a village in the remote area and on the way back you broke down, or a massive tree came across the road, you were stuck. You couldn't go to the hardware, you couldn't cell phone.
Right.
You needed to have all your tools with you. So you packed in more than you might ever need, but you gave it careful thought.
And you were prepared.
Right. So power of attorney is exactly that. It's just a big toolbox. Some people, if you open their toolbox, they got nothing in it, or they don't have the right tool. Like, I need a Phillips screwdriver. All I have is a flathead. So,
Right.
yeah.
Well,
So my point is if people think they have this taken care of because they have at some point did a power of attorney, or maybe they printed it off the, downloaded it from the internet, it may not do what they think it's doing. It needs to be customized.
all right, let me ask a question then. If somebody says, okay, I'm at the point right now, especially with COVID, now that has sparked me to want to take care of my affairs. Would you recommend that somebody consult with you privately before they bring in somebody? I want Johnny here to be in charge, explaining the powers of attorney and what the limitations are, or that there are no limitations. Do you want your client to know? Would you feel comfortable explaining all that with Johnny, who's going to be the financial person? How would you ultimately like the first meeting to happen with someone?
It's a lot of it. So first of all, the attorney-client relationship is very sacred.
Yes.
Right, still
Right.
is. And so you're free to share whatever you want with your attorney, and they are not able to disclose it. So that's a good idea. At some point, the attorney needs to meet privately with their client, make sure this is what their client wants. Like, for instance, the older the client, the more reluctant we are to have the family making the decisions, because it's like, well, who's really speaking here? Is mom just a puppet?
Right.
However, there's nothing wrong with having the family in the conversation. So I have it kind of depends on the relationships. I would say at some point, the designated person needs to at least know this has been done,
Right.
and it helps them to understand their responsibility. So I can look at you, using you for an example, and your child is here, and you're going to name them as your agent. I'm able to look at them and say, you understand that you have your total duty is to your mom. She's my client. I'm not your attorney. You're not my client. She's my client. We can make all those roles clear. You have to do what she says. Some people think by doing a power of attorney, it gives them a trump card. So kids will call and say, Dad's being difficult and he's trying to escape the nursing home or assisted living, and we need a power of attorney. I'm like, well, what's that going to do? Well, we can keep him in there. Well, no, you can't. Just because he names you an agent, you're his agent. You're not his boss. So
Yeah.
So again, it's important sometimes for this conversation to happen with some or all of the family.
I have one more question for you. with cognitive functioning, and how does an attorney determine whether or not somebody is capable of entering into a legal contract? This has been something that I'm working with now with somebody, and the doctor knew that this person had dementia long before, and it seems like I would say, with how do you figure that out as an attorney? How do you know that?
That is a very...
I know, tough question.
It's a difficult question, but it's a crucial question.
It is.
Especially for attorneys. So as, a lot of my work falls under the umbrella of elder law. So I work so much with people in that last quarter of life, and we do the Medicaid planning and speak about VA benefits and all that. But that is an assessment we make every single time. Doesn't matter the age, but so there are legal standards. And interestingly, wills and trusts, powers of attorney, deeds, beneficiary designations, all of those legal decisions have different standards of capacity. Wills and trusts have a pretty low level. Powers of attorney have a higher, so do deeds. So it'd be too much to go into in depth, but part of it is observing. Are they, kind of like those mini screening situations? Do they know? Do they appear to be in control? Do they appear to be under the influence of someone? If I'm trying to hold a conversation with you and
someone else keeps,
and they're, so how many children do you have? 5. Where do you live? Livonia, or Westland, I guess.
That happens in the doctor's office
so
as
yeah,
well.
at some point you have to say, whoa, would you mind leaving the room? I need to know, is Barb able to communicate with me? Can she hold the information and provide the answers and make decisions? So we're not mental health professionals. There are many times if I think a client, it's questionable, either I'll back out or I will say, I need you to get a letter from your doctor that says they believe, in their medical opinion, you have the capacity to enter into this. And this is why it's so important, Barb, for people to plan before the door closes.
No, once it's too late, it's too late.
Yeah, it's so sad. People will call me from our office while they're in the hospital on hospice with 3 days to live, potentially, and it's like, oh, we need to get things in order. Well, hopefully we can, and we try, but there are times when it's just not possible. It is too late.
Well, that's exactly why we did this show, and I want to thank you so much for being our guest today.
Oh, my pleasure.
And thank you and the viewing audience for being with us today.